Good evening. I'm Dr. Imani Brown, the Director for the Social Equity Program for the City of Los Angeles, Department of Cannabis Regulation. Welcome to this webinar sponsored by the Business Licensing and Compliance Assistance Program. Now, BLC programming is designed to assist social equity applicants in the City of Los Angeles as they navigate through their entrepreneurial journey. I will be your moderator for tonight's session. This installment of our 2024 Spring and Summer webinar series focuses on operating agreements, business operations, and governance. Now, before we get started, let's take a minute to review some housekeeping rules. Please note that this webinar is being recorded and can be viewed only on DCR's Learning Management System, or our LMS, after the editing process. You will be muted with cameras off for the duration of the webinar. This means that your camera and audio functions will not be available to you during this session. However, you will be able to see and hear all the panelists. There is an open chat box where you can interact with one another for networking or comment on the information. Please use caution when sharing personal information in the public forum and keep your questions focused on tonight's topic. Please ask questions about tonight's subject matter in the Q&A box. We are gathering and responding to your questions throughout the presentation, and we'll have a Q&A session where you will also get responses in the last portion of tonight's event. You are encouraged to utilize the Q&A box at the bottom pane of your Zoom screen. If you use the Q&A box for questions, everyone will be able to see the questions when they are answered. Finally, please note that tonight's content was not created by the Department of Cannabis Regulation or the City of LA and is for informational purposes only. This information is subject to change and does not replace or supersede the Los Angeles Municipal Code, nor constitute legal advice. If you have specific questions outside of tonight's topic, please call 213-978-0738 during our business hours, which are Monday through Thursday, 10 to 4, to speak to a DCR representative. And now I'd like to introduce Tony Forge. For over 28 years, Tony Forge has worked as a litigator, managing attorney, state mediator, and associate general counsel. A graduate of UC Law in San Francisco and the University of San Francisco. Tony is a leader in compliance and litigation management. She has acted as Chief Compliance Officer for major Fortune 500 companies and has implemented several litigation management programs for global insurance companies. Tony co-founded Four Leaf Consulting in 2016. Four Leaf Consulting is a California-based cannabis licensing and compliance consulting firm dedicated to offering clients a practical approach to establishing their cannabis businesses. Four Leaf Consulting specializes in local and state licensing, interpreting cannabis regulations, strategic partnerships, contract negotiations, and drafting operational business strategies. Tony has a passion for social equity in the cannabis space. She consults and shapes policy for social equity cannabis organizations in Oakland, Los Angeles, Long Beach, and New York. She recently co-authored the Social Equity Advocacy Handbook, which outlines best practices and procedures for those municipalities and groups advocating for cannabis social equity. And with that, I'll turn it over to Tony.
Thank you so much, Dr. Brown. And thank all of you for spending your Tuesday evening with me, especially after the Memorial Day holiday. And I hope you all had a great holiday. This is a subject matter I am so passionate about because, as Dr. Brown said, in my previous life, I dealt with this all the time. I dealt with business operations and governance. And since I've been in the cannabis space, one thing I know for sure is that this isn't top of mind, and I don't know why. It should be. You do not know how critical it is to have the correct operating agreement, to make sure it has all the provisions in it, to make sure you have your corporate governance together, as well as your business operations. And so the conversation we're going to have tonight is we're going to cover all of this. And the reason why this is so important, because I don't know if you all know, but now we're during the comment period for rescheduling. And so, as you all know, it's going from a illegal Schedule 1 drug to a Schedule 3 drug. And that also means we have a lot of people entering the marketplace. That's what we think. We also think this is a time that people are going to want to just absorb businesses, buy businesses. And if that is your intention, I don't think everybody wants to stay an entrepreneur all the time, then you need to make sure that your business is buttoned up. And companies do due diligence. I used to do that in my old life. So I would go into other companies and say, do they have records? Do they have agreements? Do they have articles? All of those things we're going to talk about tonight. And so I want you to be keen when you listen to what I'm saying regarding operating agreements and the such. So for all of you that are new, you're just applying and you don't know any of this, you're not operating, it's a good time for you too, because you need to know this stuff before you get investors, before you talk to partners, before you sign all of these agreements. So even if you're new to the industry, even if you're an operator, I think you're going to learn a lot tonight. And I'm just so interested in hearing your feedback and your questions after the presentation is over. So before we get started, I got to do the disclaimer again. Ethan? The information provided in this presentation, in this webinar, is for educational purposes only and does not constitute legal advice. So what is corporate governance? I know it sounds like a lot, but you know me, I'm very practical, plain English. Just simply stated, it is the rules, it is the processes that govern your cannabis business. And why it's so important? Because it encompasses every sphere of management, from your action plans to your internal controls to performance measurement. You know that as KPIs, key performance indicators, as well as corporate disclosure. And so when I was putting this presentation together, to be really honest, I kept thinking to myself, why is it an afterthought? Why isn't this top of mind for cannabis businesses? Because it's so important. And I really think it's fatigue. I absolutely know it takes a lot to get those licenses together. It's a long process. It's usually a year and a half, 2, before you get to be operational. And then it's all of this excitement regarding, oh my God, we're operational, let's get it to going. And we never really take a pause. We never take a pause and say, do I have my internal house in order? Do I have corporate governance? Do I know the processes and procedures? Are those articulated somewhere? Are they defined somewhere? And if nothing motivates you enough, let the money motivate you. Because what we're seeing nationally, and I do work outside of California, is that investors are not really wanting to put their money with social equity folks, the social equity operators, because it's this lack of corporate governance. Remember, they want to make sure they have a buttoned up business before they invest in it. So why is this important? It's important for a lot of reasons. Number one, it's important because, again, we want to make sure there are articulated processes and procedures. Everybody should know what they're doing. And the corporate governance sets the stage. It sets that roadmap so people absolutely know what they're doing. And it also makes it that, and it's not on this slide, Ethan, but we'll there you go. It gives investors and stakeholders a clear picture of the direction and the integrity of the business. Also, investors want to make sure the business has ethical behavior. So it's not all just about the money. So how this plays out, and this does play out in the cannabis business, I want you to go back to a couple of months ago where we saw an LA Times article. And in that LA Times article, it was talking about Stizzy. And the allegations were that a Stizzy operator was engaging in unethical behavior by having a trap house. And we all know what a trap house is. It is a unauthorized, can be a home, could be a building where you are selling cannabis and you don't have a cannabis license to sell cannabis with. So these allegations came up, and it really did kind of put the investors and the stakeholders on pause. What I understand is that as a result of these allegations, that particular operator, that particular owner, allegedly is no longer part of the Stizzy organization. And so it's not only about making money, it's about making sure that you have a good reputation. There has to be integrity in business. So let's look at it outside of cannabis. Let's look at it with the Shein. I don't know if you all watched CNL last week, but they really talked about this whole notion of fast fashion and Shein having the reputation of not having integrity because allegedly they really overwork workers and the such. And this really put a downward kind of look at Shein to, do we really want to be part of this industry that does not treat its workers allegedly well? And so we can see how it plays out in real life. And like I told you before, investors want to make sure that you have controls in your business before they're going to give you any money. It's just that simple. They do that because they really, really know there's financial viability, there's financial security in the long run if you have your house in order. So, what does corporate governance look like? I always try to give some real life examples. It is merely your documented policy management system. It could be SOPs, standard operating procedures. It can be KPIs, key performance indicators. And if you have a dispensary, some of those key performance indicators can be your inventory turnover rate, your break even point. How many customers do you get a month? How much does the average customer buy in terms of product? All of those things, people who are investing in your company want to make sure you can tell them that, because that's part of the pitch. That's part of the story of why you're telling them you need to invest in my business. We need to make sure you have internal audits. You can't just assume everything is running well. You got to go in there. You got to make sure everybody is doing what they're supposed to be doing. And employee training protocols are extremely very important when you're talking about corporate governance. And absolutely why. We're going to talk a little bit about this when we're talking about cost savings, but it is very imperative that your employees absolutely know what they should be doing. We're going to talk about this later on. You need a handbook. You need to have processes and procedures for the employees. So you see, it's this multi-dimensional approach, right? So we have the record keeping, we have the key performance indicators, we have SOPs, and we have documents that our employees absolutely know what they should be doing. So what's the bottom line? Like I said ad nauseum before, investors, shareholders, before they put money in your business, they want to make sure you have processes, you have rules, you have procedures. Compliance is key. People want to make sure you're complying with all of the local rules, the state rules, the rules that govern your LLC or your S or C Corp, your business in general. And I always say, no captain wants to join the ship without a navigation system, because what are you doing? If you don't have a navigation system, you are just floating in the water. You don't have a port of call. You don't have a direction that you're going to. You're floating, just hoping that you're going to get there. And this is business, people. We don't work with hopes. We don't work with dreams. We work with strategies. we work with calculations, and we work with data. So let's talk a little bit about corporate formation documents. And this is so important. And if you're a new applicant, you really need to listen up. So if you are just getting your licenses, or if you're thinking about, I need to get some investors, let's talk about what type of corporation maybe you should have. So the documents depend on what type of corporation you have. So you have an S Corp, you can have a C Corp, or you can have a limited liability corporation or an LLC. We see so much in the cannabis industry, people have LLCs. Why? It's easy to do. But there's some things that you should know. Part of that formation document you need for an LLC is an operating agreement. You are required in the state of California to have an operating agreement. You don't have to file it with the Secretary of State, but you're required to have it. Now, with an S Corp or a C Corp, you may have articles of incorporation. You are required to file those with the Secretary of State. So what is the purpose of having these formation documents? It's a roadmap, that's simple. It's a roadmap to ensure that the business runs smoothly and efficiently. And we're going to talk about all these bullets later on in the presentation. It ensures that all the parties understand their rights, their responsibilities as a business owner. It outlines the operations and the management of the company. It dictates the financial and functional decision-making of the business. We're going to talk about that. Member managed, or is it managed members? We're going to get all into that. And it guides against internal disagreements. And my Lord, we are seeing 2 years later a lot of internal disagreements between shareholders, between business partners. And it all goes back to what's in that formation document. And for purposes of this conversation, we're going to be talking about the operating agreement. So if you're looking at two types of LLCs, one is a single member. I usually see this when a person is just starting their application process. They just put them, they don't have investors yet. You can always amend it, bring some investors in. If there's more than one investor, that is a multi-member LLC. Now, I get this question all the time. Tony, can you send me a sample great operating agreement? No, I can't, because they're extremely specific. It really depends on the deal that you're negotiating. So I am not a template person. I'm going to talk about it later on. I think you can use that as kind of this foundational document, but you have to make sure the provisions that are part of your operating agreement are addressed. And so you can use a template, but everything that we're going to start talking about is the meat, right? The template's the bones, you got to put some meat into it. And so let's talk about the first set of critical provisions you should be looking at and you should be discussing when you're talking about your operating agreement. First, it's the governance structure, right? It's that whole management piece that we talked about at the beginning of this presentation. So part of that governance structure looks like, what are members' ownership percentages? What are voting rights? What are the managerial duties going to be? How is this going to be structured from a management perspective? Even how are meetings going to be held? Operational duties. Who's going to take care of the daily stuff? Who's going to make sure that daily operations are going flawlessly? The other part of that is capital contributions and distributions. This is also important, because this is where you're going to discuss how am I going to get my money at the end of the day, my distributions. It also talks about financial commitments. So you can put in language that basically says, Cheryl's going to give $150 million to this agreement, or excuse me, to this business. And then you can also put, well, Tony doesn't have $150 million, but Tony has in-kind sweat equity. And you can put that. There are some operating agreements where people would put a price attached to the in-kind or the sweat equity, right? And so it could be something in-kind services amounting to $50,000 or something of that nature. So it can be that specific. It doesn't have to be. You can simply say in-kind services, or you can state how much cash contribution or whatever you are contributing in terms of capital to the business. Protocols for distributing cash. Now, this is really, really important. And I always tell my social equity operators to really look at how they're going to get the money, because I really see this with a lot of MSOs. So what the MSO will do for the social equity operator is say, look, we're going to give you a line of credit. That credit is for $5 million. Let's say it takes $2 million for you to get your dispensary open. Oh, and don't forget, we signed for that piece of real estate you have, and you owe us another, well, $150K for that real estate. Ooh, and we have a licensing agreement with you, and there's some money attached to that. So you really need to read the operating agreement, because a lot of operating agreements I see basically says that the social equity person does not get any distribution until all that's paid. So it's the $5 million is paid back, the $150,000 in my example for real estate, until all of that's paid back. So realistically, you might not be getting it paid until year 2030, but you should know that. And if that is problematic, then you need to say something to someone. And this information is usually found not only in the body of the operating agreement, but I'm sure you've all seen that Schedule A. Schedule A is usually attached, and that's where you have all the capital contributions. That's where you can talk about your in-kind contributions. But if it's not in the body of the operating agreement, definitely look at Schedule A for the contributions and the distributions. Transferability of membership interest, also very important provisions that you need to look at. So we're all kind of assuming, okay, if I want to transfer my interest, I can. Not necessarily. You need to make sure that you have a discussion and you know what the rules are regarding if you can, in fact, transfer, because sometimes there are restrictions on the transfer. Sometimes people want to transfer it to a spouse. Sometimes they want to do after death, put it in a trust or an estate. So you need to basically have a conversation, and we're going to talk about some of those things you're going to ask in a conversation when you are looking at interest. How do I transfer? Can I transfer? Those are important questions. Also, we see this a lot, the right of first refusal. And it basically says, look, if I'm a member and we get an outside offer from somebody else for this membership interest that's about to leave, then I want the chance in order to buy their membership interest. Usually there's a time stamp on this. So what I mean, it'll be 90 days or 120 days for the right of first refusal. But that's something that you need to be aware of and negotiate if that's something that you do in fact want to do. Also, it's very important to talk about how new members will be admitted. We are seeing now old members go, new members of the LLC coming in, new investors coming in. You need to be sure you know if I need to get a new investor to this business, how are they going to be admitted in? So, exit strategies. Oh my God, we're seeing a lot of these. A lot of folks are exiting. So, the conversation needs to be, and the operating agreement needs to reflect, how do you terminate the LLC? We're going to talk about this a little later, but is it just a simple vote? Do I need a majority vote? How are we going to dissolve it? I see so many of the statements that talk about bankruptcy. Well, that's a federal protection. Cannabis is federally illegal. So why am I going to put that in there as an exiting strategy? Maybe I can put language, and I do, in fact, put this language. It looks and it smells like bankruptcy, but I'm just not saying bankruptcy. So it is, the company no longer has any assets. The company no longer has working capital, that type of thing. I did find a case in California, interesting enough, very new case, that basically said there is some type of protection under bankruptcy if you are not operational. So you expend all this capital to try to get it up and going, but you haven't opened the doors yet. We have seen this in cannabis, so we know that in fact exists. I'm going to remind myself to send the DCR a copy of that case because I just found it recently for a client and I thought it was extremely interesting and I think it's going to help all of you. So I will definitely give that to DCR so they can post. Also, how members will exit the LLC. This is coming up time and time again. Are they going to exit again by vote? Does it have to be a majority vote? Do we have to buy them out? Do they have to buy us out? All of these things are the meat that you are going to put on this operating agreement. And so you're going to have to discuss all of these things because if you don't, I can guarantee you, because I'm seeing it time and time again now, since we have operators, been operating for around 2 years now, all of this is coming out. And it's best to talk about this beforehand than at the point, so there's no surprises. So dispute resolution mechanisms, we're seeing this as well. So you want to have the conversation and you want to put in the operating agreement. Well, does it make sense for me to have mediation, arbitration, litigation, or specific performance, temporary restraining orders? And I'll talk about all of those. So number one, I personally like a mediation and an arbitration. I like a mediation because a mediator is going to come in and they're going to try to offer solutions to the problem. And sometimes that's all you need. You need a third party to come in and help you with a solution because maybe you're too close to it, they're too emotional with it, you're pissed about it, and so no one is seeing the solutions. And that's what a mediator does. Arbitration is different, and it depends on the type of arbitration you have. So an arbitration is basically a judicial proceeding. You're in front of an arbitrator. An arbitrator can be a retired judge or an attorney, and you're basically presenting your case. If it's a binding arbitration, that means the court is going to recognize the decision of the arbitrator, and that's that, right? The court is going to enforce it. The court recognizes it. We have a decision. As if a judge made a decision or during a jury trial, the jury made a decision. Arbitrations are good if you are, number one, limited with finances and you're limited on time. You can have litigation, but things are slow. There is in LA County this notion of fast track. And when I used to try cases, fast track was, look, there is a prescribed period of time in which the court system is trying to get your case through. With COVID, that doesn't exist too much anymore, even though the theory is still there. I am seeing and was in a small trial Well, I only got to try my case via Zoom 3 days a week, and then it was pushed back and pushed back. If you're trying to come up with a decision quickly, the litigation may not be the route for you, right? You might want to go to a binding arbitration where you are going to have a decision either that day or in the next week or two, and you're not waiting months and years before you can get your day in court. Arbitration's not cheap. I'm not trying to act like it is, but it's cheaper than litigation. Arbitrators can charge from, let's say, 400 an hour to maybe $5,000 to $10,000 an hour. I have seen a retired judge charge 10 grand. Ridiculous. I'm in the wrong business, definitely. But with litigation, we know it can be expense after expense after expense, because you simply don't know what you may have to respond to in terms of motions and the such. I had pre-trial, and that means before we go to trial, we're doing discovery. And the discovery is the question and answer when you're trying to just compile all the information so you can come up with your case. So I had a case where an investor locked my client out, cultivator, and kept selling the interest in the business over and over and over to different people. Extremely fraudulent. I absolutely know that. And so we were up to $230,000, 230,000, and we hadn't even gone to mediation. So it can be pricey because it really depends on how you're responding. If they're sending you motion after motion, if you have to go to court. So mediation, always, I love it because it helps you come up with some solutions, and maybe that's what you need. Arbitration makes sense if you're trying to come up with a decision pretty quickly. Remember, binding arbitration is the arbitration vehicle you're going to utilize when you're trying to have the court recognize it as a full, final judicial proceeding. Litigation, when you got time, when you got money. Specific performance is basically a vehicle that you're going to go to court and you're going to get some type of court decree. And that court decree basically says that I want you to do a certain thing, party A. Usually I see a lot of specific performance when there's white labeling agreements or manufacturers or cultivators, because those things call sometimes for a specific act. So I had one white labeler who refused to finish the pre-roll I had for a client because they were in a dispute. And so what I had to do is go into court, get an ex parte motion, which is just, look, motion, I need to come into you court quickly because I have a client that needs an answer quickly. And we utilize that in order to get the manufacturer to finish the pre-roll. So depending on what type of action you are trying to do, and that's why you need to have a lawyer review all of these provisions and discuss all of this with you. I'm just giving you enough knowledge to be dangerous, and I'm giving you enough knowledge to ask the questions. You might not have the answer, but you know what questions to ask. And with that information, you'll be able to talk to your lawyer about all these things. Other things that are extremely important, this goes without, you got to follow the cannabis rules, regulations, inspection rights. You want an opportunity to inspect books, financials. I never go with what somebody's telling me. I need to look at that for myself. You need to look at cost sheets. You need to look at pro formas. You need to look at all that information, and you need the right to look at that. A lot of times, especially in the MSO scenario, the social equity operator just leaves that up to the MSO's people. That's okay and fine, but ignorance is not bliss. You need to make sure you know what those financials are saying, because in the example I gave you before, if they gave you a $5 million loan and they say you use $2 million of it, you need to definitely inspect those books to make sure that they did in fact spend 2 million and not just one, and you're left on the hook for the two. So inspection rights, looking at financials, accounting, extremely important. In California, again, I just want to stress, you do not have to file this with the state, the operating agreement. You are required to have one. I suggest, again, you've got to have it. Remember, the operating agreement is a roadmap. And so you should always have your roadmap handy, because if there's any of these issues we talked about before, you can simply go to the operating agreement. One thing, question I get all the time is, what does it mean when it says member managed? Because there's two scenarios in an operating agreement. It's either member managed or it is a manager managed. And that means that there's just a specific people in a manager managed that are designated as the managers for your operation. With a member managed, everybody can make the decisions. It's like a partnership. The investors are actively engaged in the business, and each member is an agent for the business. So, my favorite part of the presentation, do's and don'ts of the operating agreement. Don't use a template operating agreement that you got from somebody 5 years ago. Don't do it. Like I said, it's okay to use it as a foundation, as the skeleton, but we just went over all the meat that needs to be added to the operating agreement. So if you're going to just use it as a foundation, but you really recognize you have to fill it in, I'm good with that. Don't draft it yourself. I literally had a call 2 months ago from someone who said, I'm in a dispute with my investor. And I said, okay, so have you talked to the attorney about it? No. Well, do you have the operating agreement? Yes. What does it say? I don't know. Who drafted the operating agreement? I did. So you drafted the operating agreement and you don't know what you put in the operating agreement? Yes. So you know what happened. They just used a template. Don't do it. I mean, if you are going to do anything, make sure that you have somebody who has knowledge about how to draft an operating agreement. Draft it yourself. Don't draft it yourself. I understand funds can be limited. I see it all the time. But the problem is, all of those things we just talked about in terms of the provisions that you need to include, a lot of people don't recognize that that should be in the operating agreement. And so that roadmap that they talked about, they don't know the points of the road. And so how are they going to draft it themselves when they don't even know it? Don't do it. All right, sign an operating agreement without having it reviewed. That's how we get into the predatory nature of these operating agreements we complain about. Because I absolutely know you want the deal, I get it, but you've got to have somebody review it to tell you if the deal makes sense. Are you getting everything that you think you're getting? What I see time and time again is that people will have a conversation about what they're getting. And then when it gets to the four corners of the document, and that's the only thing that's important, the four corners of the document, it says something totally different. And so I always have this conversation with my operators. They'll tell me, well, you know, that's not what Bill said before. Well, Bill may have said that, but that's not what's on this agreement. And so I always say, have it reviewed. Blindly signing an operating agreement without having an attorney review it. I think people just believe that, oh, they have good intentions. I'm going to be a partner with them. And so I'm just going to sign it because they have my best intentions at heart. They don't. It's all about them and what they need and what they want to do with this business. And so you cannot blindly sign an agreement. Use your partner's attorney to review the agreement. I'm only worried about my client. Okay. Even if they have a partner or someone of the such, I really don't care. I represent that particular client. I've been retained by that particular client. So that's the person I'm advocating for. And so if you think, well, we're all on the same side, don't have that belief, because they might say, yeah, it's okay for you to sign, but are you really going to depend on that? Depend on the DCR to review your operating agreement. The DCR is not looking at your operating agreement for the legality of it, to make sure it's legal. What we are going to talk about at the Q&A portion of this is that there is an equity checklist, and it's pursuant to Los Angeles Municipal Code. I think it's 140. I should know that by heart. But that's what that checklist is pursuing, just to make sure those equity requirements that are part of the ordinance that are checked off in the operating agreement. But if it's legal, if it's sound, if it's anything else, they're not going to do it. That's not their job. Accept the response. Well, the DCR accepted the last one I submitted. I hear that all the time with MSO attorneys. So we just talked about before, the DCR really isn't looking at it in terms of its legality to make sure all those things we talked about previously are included. They're only looking at it to make sure that equity checklist has been addressed. And so don't accept that as well as an excuse. Two more things I'm going to put don't that I did not put in this slide, and I really thought about that today because it happened today. Don't be rushed into signing the operating agreement. So many times you'll have somebody, well, you need to hurry up and sign. You need 24 hours. Don't do it. Don't do it. Basically tell them this is a legal document. I have got to make sure that it's reviewed by an attorney. If you don't understand that, I'm sorry, but I am not going to move forward until I have this reviewed by an attorney. The other don't this is the first question I ask when I get an operating agreement from opposing counsel. I always ask them, is this negotiable? If they tell me no, I'm not going to waste my client's money and time. I'm not going to go any further, because if I can't negotiate all of those things that we talked about previously, I don't want to do this operating agreement. And then you have to think to yourself, do I really want to be in business with someone who will not negotiate with me? I'm supposed to be their partner. We're supposed to be able to talk to those issues. If they give you an operating agreement and say, you need to take it as is, I always tell my client, you shouldn't be in business with that person. The do. You are going to retain, and you should retain, an attorney separate from your partner. We talked about the reasons before. You need to have an attorney review all the ownership documents. So I work a lot with MSOs, so I always use them as my examples. So when I get the operating agreement, I usually get a lot of other documents. So I could get a licensing agreement attached to it. I can get a line of credit agreement attached to it. I can get the real estate kind of agreement attached to it. And the operating agreement will refer to all of these things. It's incorporated by reference. And so you need to make sure that the attorney reads all of those documents, because they're going to be referred to, I can guarantee you, in the operating agreement. And you need to make sure that all of that is legally sound and it's not working against you. One thing that I have found in the line of credit, they will ask for a personal guarantee. I had a client that didn't know what that meant. That meant you were on the line personally, you for the $2 million in the example that I gave before. And so, therefore, it's really, really important to have an attorney review all of those ownership documents, all of those formation documents, all of those loan documents, because they're referred to in the operating agreement. And you absolutely need to know how they really play out and if they're not going to work in your favor, or, like I said, if you may be personally guaranteeing something. I always say you need to utilize the DCR's pro bono, low bono legal services. Dr. Brown has talked about this. I think it's $35 an hour. Dr. Brown, if I have that wrong, or DCR, if I have that wrong, correct me in the chat. But it ain't gonna be $300 and $400. It's your best bet. And if you don't have a lot of money, what I suggest people do is just go over those critical provisions we talked about. You can retain an attorney for an hour or two, and you can say, look, this is what I want you to look at. I want you to look at distributions. I want you to look at capital. I want you to look at governance. I want you to look at exit strategies. I want you to look at dispute resolutions and really go what you want to happen, and try to have your attorney work with you that all of that is articulated in the operating agreement. So I always tell my clients, I give them a questionnaire. A lot of these questions are on the questionnaire. And I say, if you have a designated investor or a partner, you need to sit down and have a conversation with them. My colleague Yvette always talks about, it's like a marriage agreement, right? And it really, really is. You have to come to a meeting of the minds. That is what a document's all about. The document is memorializing the meeting of the minds that you have between you, your shareholders, or your partners. And some of those questions are these: what are going to be our exact percentage of ownerships? I can't tell you how many times I look at the ownership percentages and they total 130. And I'm like, how did you get an 130? Well, if the social equity person has to have 51%, a lot of times they're just giving away, ownerships and percentages and equity, and they're really not looking at it to see if it is 100%. So remember, you got 100, you got to work with that. You've got to keep 51%. So that's 49 you're getting rid of, and that you're selling out, and people are purchasing for equity in your business. But you have to be mindful of that. Who is going to be a member, or who's going to be a manager member? We talked about this before. Remember, the members of the LLC, everybody, it's member managed. Everybody is responsible. Everybody has a duty of loyalty, a duty of care to the business. Or are you going to have a designated group? Maybe you don't want to manage the business. Maybe you don't want to have decision making. Or a lot of times we see with MSO, they have a designated person that they want to make all those management agreements. But you need to have this conversation with your investors and your other partners. Again, review what the corporate duties are. Who's going to be responsible for what? Who's going to make those daily operational decisions? Is that member managers? Is that going to be this specialized group of people who are managing the business? Who's going to make the significant management decisions, and what constitutes a significant management decision? Other things you need to talk about, we talked about it before when we talked about those provisions you need to look at. How can members be admitted? How can members be terminated? Can you just vote them out? Do you need cause? There has to be a reason in order to get them out. We talked about how the LLC is going to be dissolved, mediation, arbitration to help settle disputes. Do we want one, the other, or sometimes you want both? I typically do both. I have you start with mediation. That's cheap. Maybe we can resolve it first and then go for binding arbitration. But that's a conversation you need to have. Does it make sense to have specific performance clause if you're in a cultivator or a manufacturer? And that is, specifically having a party do a particular action. Does it make sense if we're manufacturing that we have these conversations that even though something may go awry, you still have to do what we agree that you're going to do. You're going to make the pre-roll. You're going to white label the gummy or whatever. But you need to make sure you have that conversation as well. Other things you need to be talking about: who will have voting powers? Is it going to be everybody or just a certain amount of people? I have seen in a lot of operating agreements where it's just a certain amount of people with voting power. And you need to really think about that for all those reasons why we said before. Does the voting power equal their ownership percentage? So if I'm 51%, 51% voting power, or if it's going to be equal across the board. Plus, you're going to get into that when you're looking at your checklist for the LA Municipal Code, has all of that in there as well. What happens if the vote is deadlocked? Believe it or not, in a couple of operating agreements, I'm the deciding vote. If they're deadlocked, then I step in and I make the deciding vote. When and who will meet? Are meetings going to be once a quarter? Can they be in person? Are they going to be by Zoom? Do you need notice for a meeting? Are you going to call in? Notice is important because do you want people making decisions about your business? And we've seen it in operating agreements where they can just simply call for a meeting without giving you notice. So therefore, it's imperative to have some type of provision in there that says, I need notice for these meetings before you make any type of decisions. Other considerations. This is something that is my pet peeve because I'm really seeing how a lot of shareholders and owners are taking advantage of folks that are not familiar with the duty of loyalty and the duty of care. The duty of loyalty and duty of care are basically inherent in you as being a business owner, right? So as soon as you get to be a business owner, part owner of the LLC, those duties are activated. Just the same, similarly, when I became a lawyer, I had fiduciary duties that I had to be cognizant about. So the duty of loyalty involves acting in the best interest of the LLC, your business, and avoiding conflicts of interest. The duty of care requires all the members to act in good faith and with reasonable care when managing the business's affairs. Now, we're going to talk about that a little later because it's extremely important and what I want you to really pay close attention to with how you can violate those. Because we're going to talk about what the recourse looks like for violation. Other considerations, I talked about this before. As a social equity operator, you have got to look at Los Angeles Municipal Code section 104.20. This gives the ownership percentages and equity share requirements for social equity folks. I always include it. Not only do I include it by reference, I literally put in all of the text and the language so everybody is absolutely clear about what that says. One thing that I always put as particular note, there is an addendum in that section that I put in every operating agreement. And the addendum says, any provision inconsistent or in violation of equity rules such as provision or equity rules, comma, sorry about that, such provision is ineffective, unenforceable, null, and void. And so even though the rules say you should put this in your operating agreements, I see so many times people don't. And that is a protection that the city is giving to you. This ordinance is given to you. So I really want you to be cognizant of that, and definitely make sure you look at that municipal code so you are having all of those provisions in there. You know what it says, and all your equity checklists, all of those requirements are in that section. You and I both know you have to comply with all the state and local laws. That's what we all have to do. Okay, so duty of loyalty, we talk about it's implicit as you becoming a business owner, and it's your duty to make sure you don't violate any of these things. And violations can happen in a lot of different ways. If there's a conflict of interest, if there's a failure to disclose important information, I see this all the time where a lot of the business owners do not disclose information that can really impact, like I said, the ethical wherewithal, for lack of a better term, of the company. So you need to make sure you disclose everything. Everybody knows what they should know. And so you're not violating this. Misuse of company assets. We saw this in the allegations against MedMen, that the allegation was that they were misusing company assets, allegedly, for their own personal financial gains. And that was something that the shareholders were upset about. A breach of confidentiality. This can happen when we have trademarks. This can happen when we have copyrights. This can happen when we have information that is just supposed to be privy to the corporation. And so you need to make sure you're not violating your duty of loyalty to the company. The duty of care is that you're going to act like a reasonable business person with care and prudence. Some of the examples of this violation is non-compliance with the regulations. Yes, with the cannabis regulations. If you are just operating with a local license, you know, in California, you need a state license too, and you're not even doing that. You're just kind of, well, they're not going to really look to see if I have a state license. Yes, they are. Non-compliance with those regulations could be a violation of your duty of care. Inadequate employee training and failure to maintain safe business operations. We saw this in the Midwest because, believe it or not, there was somebody that passed away in a cultivation facility because they did not have the proper respirator on and the proper ventilation. And unfortunately, they died. And so I happen to know one of the attorneys that is going to litigate this case. And one of the things, the legal theories that they're using is that the business, the LLC violated, all the members violated their duty of care. They had a duty to make sure that there were safe conditions for the employee, that they gave the employee the proper mask, respirator, and they had proper ventilation. Also, any poor quality controls, that could be a violation of your duty of care as well. Company recourse. The reason why I'm putting these slides up here, we're talking about duty of care, duty of loyalty, because we see so many people doing number one, removing you. because that's what they want, right? They want the company, they want to make sure they get more percentages. And so they go to the court and say, these are the instances in which this person violated the duty of care, violated the duty of loyalty, and you can be removed from the company. You also can be fined. There can be an injunction. An injunction is basically a court order that causes you to stop doing something or tells you to do something. It's one of the two. It can be a lawsuit or you can be sued for damages. Now, T-Forge is not an accountant, but I put this slide up here so you know you have taxing, you know you have reporting, you know you got 280E. You need to talk to a tax professional about all of that. You need to know with LLC, what should I keep in mind in terms of filing taxes, in terms of reporting to the state, what those requirements are for your LLC business or your C Corp or S Corp. So you definitely need to talk to a tax professional. Business operations. All right, we talked about the fatigue, right? We talked about, well, I think maybe people aren't really into governance because they're doing so much in terms of getting the license, getting all the inspections, everything. What I also see is operating the business is kind of this is what I hear all the time. Well, I've been selling weed for 45 years. Selling weed for 45 years is not operating a business. We are in a regulated market. This is a business. And so I just want to go over some key concepts with business operations and talk about them and why they are important. Okay, I always say a widget is a widget is a widget. There's no difference between a cannabis business and selling hair. The only difference would be the widget is cannabis versus hair. Now, I get that it is federally illegal. We got that. It's highly regulated. We got that. But the nuts and bolts of it is you have got to be able to operate a business. People want to make sure that you have business acumen, that you understand what it takes to operate your cannabis business. Being an entrepreneur sometimes sucks. It's a lot of things. You're juggling so many things. But that's what we decided to do when we decided to step out and own these businesses. So let's talk about some of the just basic business considerations that you need to think about when you're looking at your cannabis business. First thing, have you developed a mission statement? Like I said, worked in corporate America for 150 years. And when you work in corporate America, you know messages come from the top down. The CEO and the executive board, those are the people that create kind of the messaging for the company. Everybody kind of absorbs the messages and you get what the company should be doing. We call it, you get your charge. You know what your charge is. I worked for one company where the CEO would literally go around to everybody, from the janitor to the lawyer to the accountant, and say, what is our company mission statement? If you knew what the company mission statement was, you got a $500 bonus on the spot. If you didn't know what the company mission statement was, you got dinged by your manager. And the reason he did this is because he wanted everybody to understand what it is that we're doing with this business, why we're doing it, what we're all about. Something similar could be this elevator pitch we talk about, right? That you're in front of an investor and you have maybe a couple of seconds or a minute or two to pretty much tell your investor what your company is all about. Mission statement does just that. And I always get the question, how do you develop a mission statement? Well, you develop a mission statement by answering these questions. What do we do? What are we doing as a company? Why do we do it? Who do we do it for? And why is it important? If you can answer those questions, then you are on your way to formulating the mission statement for your business. So I wanted an opportunity to look at Cresco Labs mission statement. We know they're in the cannabis industry, and basically they are dedicated to normalizing, professionalizing, and revolutionizing the cannabis industry. Reflects the goal of driving innovation, education, accessibility in the rapidly evolving cannabis market, fostering positive workplace culture, and ultimately aiming to improve people's lives through responsible use of cannabis. So they told you what they're doing, why they're doing it, what they're doing it for, all of those questions that we said that you need to answer. And you need to do it for your business. Sometimes I use the mission statement for my business, even though I'm a one chick operation, because it keeps me on course. When I try to go off something else, it'll keep me, okay, Tony, why are we doing this? You are offering practical cannabis solutions to people. That's your mission statement. That's what you're all about. And so you can really use it in order to develop your staff. We're going to talk a little bit about that later on. And really, everybody stays focused, your investors, your partners, with what the goals of the company are. Another business operation we really need to look at is cost control. This happens usually after a couple of months or a year of operating. Usually when people get started, cost control goes out the window. They think they need everything. I'd rather have so much at the beginning and then scale back eventually. But it involves identifying and reducing expenses to increase profits, eliminating unnecessary expenses and reducing overhead, and you're adapting to market conditions, changing market conditions, and providing valuable data for decision making. This came into play. I just happened to hear a client talk about it when we were in the room. I had no idea how expensive Weedmaps was. Absolutely no idea. And so they were really looking at the data of customers. How are they getting their customers? And so in the beginning, they had one of these expensive Weedmap packages. It was over $25,000 a month. I couldn't even believe it. And they were comparing the Weedmaps customers that they were getting as opposed to getting customers organically. And what I mean by organically was, social media, doing direct mailers to people, handing out flyers, neighborhood. They were really doing this concentrated word of mouth organic assessment. So with that data, they were able to make some decisions. And the decision was, no, we're going to still have Weedmaps, but we're not going to have the package that's really expensive. Maybe we can go with the lower to medium package because we do see the value in that. But let's really, really look at, organically doing what we're doing because we're really getting an uplift. That's what cost control is doing. It's really assessing and looking at, do I really need this? Do I really need 5 people working on one particular shift when I only have 20 people coming in? And I think 2 or 3 people can adequately service them. So you're looking how to control costs, because remember, the bottom line for all your shareholders is they want to see a profit. They want to see some money coming in the door. So it makes sense for you to look at cost control. Risk management. That's what I do as a lawyer all day long. I mitigate risk for folks. That's what compliance is all about. It's mitigating risk. We want to make sure that we identify, we again mitigate any potential risks or uncertainties. We protect the reputation of the business. I don't know if you all get the LADCR, social media stuff. I do. So I see it all. And I kind of noticed recently all the recall information. So as I would do in risk mitigation, we want to make sure that we complied with everything. Everything is under control. We followed all the processes as in the compliance, because we don't want to be part of that LADCR recall meme that comes around sometimes. But that is what you need to do. You need to promote and make sure the reputation of your business is not harmed by making sure you're doing things the way they should be done. You're compliant. You also want to promote the safety and well-being of your employees. You want to prevent incidents and injuries. We see this all the time, even when you go to the grocery store. You see a yellow cone. They might have wiped up the water, but in order to really mitigate any risks, they're going to put that yellow cone on there so you know it is wet. They don't want you slipping. They don't want you falling. They don't want you suing. They don't want to pay damages. So risk mitigation is really, really important for your business. Efficiency. Everybody wants to be efficient. It doesn't make sense to waste time, energy, and effort when you don't have to. That's just the bottom line. So you want to reduce your costs. We talked about that before, but you always want to maintain and improve your productivity. Again, this impacts the bottom line. It contributes to the overall profitability. That's what your shareholders are really, really looking at. And you just don't want to waste resources. I get it. It's limited resources. You're trying to do a lot with a little, but you have to be efficient when you do it. And you have to make sure you're not sacrificing quality or service to be efficient. Scalability. Scalability and growth are really important. This usually happens a couple of years down the line. I see it in my clients really who are in Colorado, who are in a much more mature market. So with scalability, the business really looks at how much can they grow and expand. I did kind of this due diligence with a dispensary in Colorado, and some of the markers we were looking at is, do we have a secure customer base? We know we have a customer base of 24 to 32. We've got them locked in. They come every week. We know how much they buy. We're pretty much understanding what our profit is looking like for a monthly basis, a 6-month period. And they decided, okay, it's time for us to grow. And so they did not have a delivery service attached to that. And so they decided, you know what, we're going to scale up. We're going to attach delivery to our brick and mortar dispensary services. So the thing that's really, really important is you want to add more, but you don't want inefficiencies and bottleneck. And this is important because you have to have the right staff and the right employees to do it. It makes no sense to scale up and to grow and expand, and you don't have the requisite staff in order to meet this new demand of the market. Why you should scale and grow, it always adds to your business's valuation. Is worth more, right? Because now, not only do I have a brick and mortar dispensary, I'm adding this additional value added proposition of a delivery service. So scalability and growth important, but it has to be done at the right time. It's going to be done when you're absolutely operating. This is my pet peeve when people have a lot of different licenses. I always believe you got to get something done correctly and know how to perfect and do it before you move on to something else. I see people who have multiple licenses And a lot of licenses just kind of stay there because they don't have the one license they really want to use. They don't have that under their belt, excuse me. So before you scale up, before you grow, definitely make sure you are secure with your position in the marketplace. You don't want to scale up and grow needlessly, and then you become inefficient, and then you have just going down the rabbit hole of it's not working out the way you planned it to. Employee engagement and human resources, extremely important. So Ms. Kindness Ramirez and Robert Chalala just did a UCLA study which talked about employees in the cannabis industry want to be developed. They want a development plan. They want to be managers. They want to be district managers. They want a career path. And so it is really important for you to engage your employees. It's important because you don't want a lot of turnover. A lot of turnover costs you money. It costs you money because you got to advertise for new employees. You got to train them up. You've got to utilize your people to train them, which is taking them away from other resources. And so it becomes an expenditure, right? And so it's best to really look at the staff that you have and truly, truly engage them and develop them. Another thing, oh my God, people, look at wage and hour rules. I have seen so many labor violation letters come in recently because people are not looking at wage and hour or their HR protocols and procedures. You need to have an HR handbook. I hope you all know that. You need to make sure your people sign off on that HR handbook, that they read it, that they understand it. Because I can guarantee you, if one person, one of your employees calls the labor board, they're going to tell another employee, and that employee is going to call. And then you're going to be calling an attorney because you're trying to get those fines negotiated down. So I cannot stress enough how wage and hour, HR, even in California, making sure you have a bona fide union. I don't know if you saw that in the headlines, that people remember the labor peace agreement that you have. There were some operators that did not go with a real bona fide union, and licenses are being taken away. So you have to make sure you do your due diligence on all of this, and you're just not relying on what people tell you. So, key takeaways. Corporate governance, crucial to a cannabis business. Operating agreements, very crucial because they outline the operations and management of the company. One note here, if you have learned something and you're thinking to yourself, I really want to amend the operating agreement, you can. So you can go back and you can talk about some of these things we discussed tonight with your investors, with your business partners. So you can modify that operating agreement. Have an attorney review all your key legal documents. That is a given. Remember, you're not drafting anything. You're not signing anything blindly. And again, you have to know a business, or you have to know business to run a business. If you don't know, my God, take a class, take a workshop, do something. And so all these concepts we talked about, you're going to use them. I mean, I went to business school undergrad. I didn't go for the traditional government undergrad degree. I've always had a love for business, so I wanted to be knowledgeable about business. I take classes still now to this day about business, so I can see what is happening in the marketplace. And I really believe you need to as well. You have got to be knowledgeable. Ignorance is an excuse at this point in the game.
Well, okay. Thank you so much, Tony. That was fantastic. So many aspects of the business for us to think about, so much important information to take away. We really appreciate your time and all of your expertise. Folks, this webinar will be uploaded to the LMS once it's edited, so you can look at this again and again and again. And so please make sure that you go onto the LMS. And this is one webinar of 140 hours of self-paced classes and webinars that you as a social equity applicant and licensee have access to. So with that, we only have about 9 minutes for questions, Tony.
I lied. I said my presentation was an hour. I lied. I got into too many examples.
Okay, it's okay. So let's get right into it. Here's the first question. Are there specific advantages or disadvantages of forming an LLC compared to other business structures?
Okay, great question. Advantages to an LLC, it's easy. That's the first thing. You have a lot of flexibility. Remember, we're talking about all those provisions. You have flexibility. You're only going to be taxed once. You're going to be taxed on your profit as part of your distribution, and your personal assets are protected. That's why it's called a limited liability corporation. Disadvantages, you got to pay, I think it's $800. You got to pay to the tax board. So that's it. Did you ask me about S Corp, C Corp, or no? Or is it just LLC, Dr. Brown?
It says compared to other businesses, so it would be compared to S Corp and C Corp.
S Corp and C Corp. S Corp, one class of stock. C Corp, multiple classes of stock. I'm remembering. C Corp taxation, you're taxed twice. The corporate taxes plus you're taxed as an individual if you're getting dividends. S Corp doesn't have to pay corporate tax. The owners just report their tax. And then it's different individuals. So meaning on an S Corp or C Corp, let me remember which one. Hold on. I think that's it. Oh, no, the S Corp, you cannot be a non-resident or you can't be a other corporation. The S Corp, you only have 100 people as your limitation in terms of shareholders. There's no ownership restrictions with the C Corp. C Corp, very expensive in order to do all the reporting requirements.
Okay. Second question, can I include a non-compete clause in my operating agreement? And what is a reasonable amount of time for the non-compete clause?
Woo! Great question. Non-compete clauses are illegal. I won't say illegal, unenforceable in California if you are an employee, right? Because the state says we want business to happen. We don't want to impede on business. So that's why they're unenforceable. However, non-compete clauses in operating agreements are enforceable if you are a senior executive. And another thing is if enforceability of the clause is so unduly burdensome, they won't enforce it. So that's new. That's a new law that just came February of this year. And so the bad part of these new laws is we don't have a lot of case law yet, right? And so I will, Dr. Brown, remind me, start looking at some different case law and give that to the DCR about this point of non-compete clauses.
Okay, great. Next question. Do you still need an operating agreement if the people in your company are your family members?
Yes! Do you know what happens at funerals? Yes, you need an operating agreement. You know, when money is involved, family is going to go off. I don't care who it is. My best friend, I'm in their company. I made them do an operating agreement. I've known this person for 40 years. I don't care. So absolutely, you need to do an operating agreement. Remember, it's a requirement in California. So you got to do it. You don't have to file it, but you got to do it.
Okay, great. What happens if my partner doesn't pay the rent, but I thought they were? Am I still on the hook for the rent?
What does operating agreement say? And that's the point. Or what is that part of that package that I said that we usually has what's going on? Are you on the lease? Are you listed on the lease? Is the company listed on the lease? Are you personally on the lease? Those are the things you need to look at.
Okay. If my partner is in charge of the retail side and there is not a profit, can I cost control their salary?
Ooh, see, this is a lot of stuff going on there. Dr. B, can you read that again? Because there's two issues. So give it to me again.
My partner is in charge of the retail side of the business and there is not a profit. Can I cost control their salary? I think that would be
Okay,
operating.
so I'm going to go with this. There's not a profit. They're not personally responsible if it's not a profit, even they're in the retail side. Remember, let's go back to what we talked about. Are you part of this member manager where you all are responsible for the operations? That's why, again, the operating agreement is so important. If you are all members, even though they may be in charge of daily activities, you still have an obligation to make sure you are doing things in the best interest of the company. Duty of care, duty of care. Okay.
Right.
Cost control. Do you have an employee agreement? What does the employment agreement say? You can't willy-nilly say, look, I'm going to lessen your salary just because we're not making a profit.
Okay. Next question. How do I develop a mission statement?
You develop a mission statement answering those questions in the slides. You really, really do. But I really think everybody should sit down and say, what is the ultimate goal do I want for my company? It's always easy with health and wellness. It's a little difficult when we talk about, let's say, dispensaries, but think about who you want to service. Think about the communities you want to service. Think about what you want to do for those communities and how you're going to do it. That's kind of how you develop it for a dispensary, as well as answering the questions that I put on the slide.
Okay. Tony, thank you so much. We have several other questions, but we are out of time. We will put these up and you will have access to them. It'll be on our website. Please continue to check our social media and keep in mind our next webinar as a part of the spring and summer series will take place June 11th on Tuesday at 6 o'clock. So please tune in. Again, Tony, thank you so much for your leadership and your commitment to this work. We couldn't do this work without you. So thank you so much. And thank you everyone for joining us this evening. Thank you.
Dr. B, quickly, if you need some additional assistance, use the coaching hours. I am one of the coaches for business operations. You definitely can do that. And we have in the chat the Los Angeles Municipal Code Equity Requirements Checklist. Definitely look at that. Dr. B, thank you. I just wanted to remind people of those two things.
Yes, thank you so much. Good night, everyone.
Good night, everybody. Have a great one. Much success to everyone.